in the Constitution, it identifies two different types of law jurisdiction. It identifies common law jurisdiction and it identifies admiralty jurisdiction. Now, admiralty jurisdiction deals with contracts. It deals with contract law. That's all it is, just contract law. Now, a little history behind our country, a little history behind the whole admiralty jurisdiction thing. And you know, some of you guys are gonna learn a little bit about some word etymology here, but going back to the founding of our country, right? 1628 and the stamp tax. Okay, so we had the stamp tax, which led to the Boston Tea Party. You know, if you guys aren't aware of it, it was extremely unpopular amongst colonists. They hated it, right? They hated it because it was taxation without representation. We didn't have the ability to say, oh no, we don't want this tax, because we weren't represented in the parliament. And so as a result, we were being taxed without our ability to be able to say, no, we don't want to be taxed. It was taxation without representation. And so what happened in 1628 was that the stamp tax came through and nobody would find anybody guilty of it. So people kept getting arrested, kept on, coming into a trial, and the jury would not find anybody guilty. The jury of the colonists would not find anybody guilty of this particular offense. And it made the king mad. He's like, well, okay, if you guys aren't going to find anybody guilty, then I'm going to eliminate your ability, and I'm just going to have my officers be able to operate arbitrarily, right? So what happened back then was that the king switched us from common law jurisdiction into admiralty jurisdiction. And the reason why is because in admiralty jurisdiction, you don't have the right to a jury trial. In admiralty jurisdiction, it is a court-martial. It's the same thing that was going on down in Guantanamo Bay in 2004 with Rochelle versus Bush, right? And so what happens there is that the allegations come in by an agent of the state, a prosecutor, whatever, and they bring the accusation against you. You're presumed to be guilty, and then they bring you into this sham process where the judge acts as both the judge and the jury in this process that they say is valid. It's not valid, but that's what admiralty jurisdiction is. It allows for the king's agents to be able to bypass the fair and neutral decision maker of a jury to be able to do whatever they want, right? To be able to tax you and win. And so, Thomas Jefferson, he wrote about this actually 3 separate times within the Declaration of Independence. One time he said that we are subjected to a jurisdiction that's foreign to our laws, right? So we were subjected to admiralty jurisdiction, which was foreign to our laws. That was a statement that he made directly in the Declaration of Independence. Another reference was where he said that in most cases we're not provided a trial by jury. And so both of those had to do with what was going on at the very time there, because they knew that by this switch, what the king had done to us, it caused us to be shifted into a different jurisdiction, and we were then denied the right to trial by jury. Now, you guys, that's what information is. That's what it is. Because when you're charged by information, not by indictment, that means that the state becomes your accuser, right? The state is bringing the accusation against you through one of its agents, and when the state becomes the accuser, then the judge and the prosecutor, they both work for the same, investigators, the law enforcement, they all work for the same thing, right? I'm not saying that this is valid. I'm saying that it's not valid, but I'm telling you just the history behind this, you guys, so that you can understand where we got to where we're at today. So admiralty jurisdiction is not supposed to be within any criminal adjudication process. It's not supposed to be. And the reason why is because you guys know about the fringe around the flag, right? So the yellow fringe that we place around the flag, it indicates that it's a battle flag. It's an at-war flag. Right? That's well known. When you look at the history of England, the history of battle flags, you'll see that when you place a fringe around the flag, that is a battle flag. Okay? And so it means that you're in a battle condition. It means that they're warring against the people. That's why we're at war against the government and the public officials, because they are warring against the Constitution, because they have placed us into a state of battle. And so they placed the fringe around the flag. Now, our founders and forefathers, they knew that the moment you place a fringe around a flag, your right to trial by jury goes away, which is why almost every single state constitution, if you read them, especially the state of Massachusetts or the state of Virginia, it says the right to trial by jury shall not be infringed. Shall not be infringed. That's where that word comes from. Because when you infringe a flag, your right to trial by jury goes away. Our founders knew that. That's why the right to trial by jury shall not be infringed, because the moment you place a fringe around a flag, your right to trial by jury goes away. Okay? So, no, you're not supposed to be able to infringe a flag, and yet here we are in the infringement of the flag, and so as a result, we know that we're in admiralty jurisdiction, and they are operating without lawful authority. Now, the things that we have, so what is the remedy? The remedy is we have to follow the Constitution, because when we charge by way of information for a criminal adjudication, we're in an infringed state. Our right to trial by jury goes away. That's why the Constitution states in Clause 1 of Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So the Fifth Amendment was put into place to make sure that all of you are guaranteed the right to trial by jury. Our founders were very, very intelligent men. What they created was a very, very robust document that protects us in ways that we can't even imagine, because of very simple words. I brought up the whole billing situation last night, where the bill of indictment derives from nobility, right? And if you are nobility, it means you can't be billed for a crime. These are the origins of these words. The infringement of the flag is the right to trial by jury shall not be infringed, right? These words have meaning and source, and our founders were well aware of it, and we can actually relive and understand these things as we are. So the right to trial by jury shall not be infringed, and the way that they protected us from infringement is by saying no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So there must be a neutral, unbiased third party there to review the state's accusations, and the accuser must be given the right to be able to defend themselves against those accusations in that grand jury. And if they don't, then that's charged by information, which means that the government has usurped its power and decided that they're not going to proceed in a duly prescribed manner by providing you with a due process that you're entitled by the procedures of process as codified in the Constitution. And so now we have a complete breakdown of the system because the system isn't functioning right. Now, I'm going to tell you guys, one last thing here. In 2004, Guantanamo Bay, right, we were bringing all of these enemy combatants, all of these war on terror, enemy combatants, we were bringing them to Guantanamo Bay, Cuba, right? And we were bringing them through these same sham trial processes. And so in 2004, the ACLU brought a whole bunch of cases, a whole bunch of writ habeas corpuses on behalf of these prisoners that were being held down there in Guantanamo Bay, because they weren't being given the right to a fair trial process. They weren't being given the right to confront the accusations against them in a neutral, unbiased proceeding. And what is particularly egregious, and the reason why I want to bring this up to you guys, is because in 2004, the ACLU stepped up to stand up for prisoners that were suspected terrorists. And yet today, however many, 18 years later, United States citizens are not guaranteed the very rights that they fought for enemy combatants and foreign nationals and suspected terrorists. And they're not fighting for us, because this is the exact same issue. The exact same thing that the ACLU fought for on behalf of a suspected terrorist down in Guantanamo Bay is the exact same issue of the absence of indictment by a grand jury. It's the exact same issue. And so the Supreme Court of the United States came out and said that enemy combatants, any one of these people, many of them are not United States citizens, many of them, all have the right to every single protection and immunity that the Constitution of the United States provides, every single one of them, including the right to be able to go in front of a neutral, unbiased decision maker to present the accusations and hearsay evidence that's against you. But they did not say that United States citizens are guaranteed those rights simply because different states decide that they want to do whatever they want to do.